Accordingly, the conviction of the appellant for the offense of murder is hereby altered to that of culpable homicide not amounting to murder, as provided under section 299, read with exception 4 of section 300 IPC. The appellant is accordingly convicted and sentenced under part 2 of section 305 PC to undergo rigorous imprisonment for a period of 7 years, with the fine imposed by the learned trial court. The period of imprisonment already undergone by the appellant from the date of his arrest till date shall be counted towards imprisonment stipulated in the sentence passed here and above. The conviction of the appellant under section 302 is set aside. The criminal appeal stands partly allowed in the above terms. Just finished. Just finished a few minutes back. You gave us so many judgments. In view of the reasons stated above, we answer the reference by holding that at the investigation stage, these articles cannot be released by a court under section 451 CRPC. However, under section 457 CRPC, the criminal court has the jurisdiction to give custody of seized property articles at the stage of investigation when those seized property are not produced before the court.
Also declare. Please, Your Lordship. Lordship, I beg to mention item number 4, Your Lordships.
Huh?
I beg to mention item number 4, Your Lordships.
Yes.
Submitted the adjournment request, Your Lordship. And we took consent from the other side.
Where is it? Okay. Item 4.
I'm appearing on behalf of Mr. A. Ganguly. For respondent number 1 to 7.
Okay, Mr.
T. Chhetri, Your Lordship.
Name is not here.
Yes, I'm appearing on behalf of Mr. A. Ganguly.
Okay, adjournment prayer has been made on behalf of Mr.
A. Ganguly. For respondent number
A.
1.
Ganguly. Learned counsel for the respondents number 1 to 7. On the ground that he wants to adjourn it. what ground?
Lordship has some personal difficulty today.
On the ground that he has some personal difficulty. Also seen the advance adjournment slip submitted on behalf of Mr. A. Ganguly with the no objection given by additional PP. Who? Will the slip? Huh?
I did not give, but perhaps someone have offered. APP has given. I can. I'll know if I see the name.
Where is it? It is somewhere. I put it somewhere. Okay, adjournment slip, which has been received by the additional PP earlier. Full stop. In view of the above, list the matter after
2 weeks or
2 weeks.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 1 of the cost list.
Yes.
My senior is as Borgohain. He is currently out of station. Therefore, I pray that the matter be adjourned for the day, my lord.
Okay, Miss. Adjournment, same thing. Adjournment prayer has been made on behalf of Miss.
K.E. Helongla, my lord.
No, who?
As Borgohain.
As Borgohain, learned counsel for the appellants. Same thing.
Obliged, my lord. Yeah, please, Your Lordship. My senior is on next. Kindly the matter be adjourned for time being.
Okay.
All right, my lordship.
This matter, Ms. Bhuya has seen it. So if your lordship, I'll request lordship to take up that partnered matter by the time she'll reach. There is another item in a supplementary list, that is Arun Dekar.
No, what is your case anyway?
Alert, he was convicted under 302, but after going through the paper book, I think it's a case of 304 part 2. Alert, there was no previous intention before the killing of, it was all of a sudden he had a single blow, and there are some contradiction in the PW, who is the eyewitness. I will show you the lordship from the.
What did you say about Miss Buyan?
No, she has on legs on some other court. She'll just come back. after
Then
5
we'll
minutes.
continue.
Well,
Yes, sir. But you can take the other matter if she doesn't reach us, then again. It's a
Okay,
request
we
from.
can do that.
No, other matter. No, there is one. There is one.
There's one more.
Partnered matter.
I will do that.
May I please approach?
Yes,
Monday, may I take the lots of the FIR again?
yes,
H4 man.
yes.
The FIR was lodged PW1 man. Kondalpo Deka man. Hamal submission is that around 4:30 PM on 3/10/15, when my elder brother Komala Deka and uncle Sri Saruram Deka were returning home from Kodomara Sapuri, the below named two accused persons who had been lying in ambush killed my elder brother Sri Komala Deka by hacking him on his neck. They also caused grievous injuries to my uncle Saruram Deka by hacking him with a sharp weapon on various parts of his body. Therefore, it is prayed before you to take necessary action against the accused persons after investigating a number. Saruram Deka was PW6 man. That his medical was done 6 days later, and the wound came out to be fresh man. That case man. H8 is PW1.
Okay, so this who's the informant?
Informant is PW1 man.
PW. Elder brother deceased.
Man.
So any eyewitness?
PW6 is the eyewitness one. Where PW1 minute
PW, okay.
is the page 8 minute. I am the informant of this case. I know the accused duo. Both are my cousins. That is son of my father's elder brother. The incident took place on 7th day in the month of Ohin, September, October in the year 2014. On the day of the incident in the morning, I plowed the land of another person. And after that, I went to Chapuri and returned from that place in the evening. While I was coming to my house on midway, I heard one boy, namely Dombaru, shouting, Komola Deka has been hacked. Well, this Dombaru has not been examined. Thereafter, while I was coming home, I proceeded to the place of occurrence, that is Koduamara Sapuri. At that place, my aunt has land measuring 6 kothas and may look after the cultivation as well as harvesting and hand over the produce to her. My aunt has land at Koduamara Sapuri. I went to the land of my aunt, and at a distance of about 1 kilometer ahead of that place, I saw the body lying on the road under a bamboo grove with cut injuries on the neck. The neck was almost severed, but a little. Somebody informed me that the accused duo caused the incident. Another uncle of mine, namely Sarumuni Deka, informed me about this. I witnessed none at the place of occurrence. On seeing my deceased elder brother, I became senseless and fell down. Later on, I regained my senses at home. Uncle Sarumuni Deka was also coming with elder brother, and Sarumuni Deka was also sustained injuries. Putuk Deka alias Hema Deka assaulted him, and the other accused person caused injury to my elder brother. I know the name of my uncle as Saruram Deka. I saw cut injury on the hand of my uncle. On the following day in the hospital, when I asked my uncle Sarumuni Deka, he replied that while he and my elder brother Komola Deka were returning after sowing seeds of Matima, a kind of pulse, the accused persons who kept hiding themselves behind the bamboo grove came out, and Orun Deka dealt a blow on the neck of Komola Deka. And when Putuk Deka tried to deal a blow on my uncle Saruram Deka, the blow fell on his hand. And then he fled away from there. The accused aimed on his neck, but he missed the aim. Elder brother Komola died on the spot. Later on, when I regained my senses, I came to know that police had come. I became unconscious at the place of occurrence. Orun Deka went to the house of Dinesh Deka. Dinesh Deka took the dhow near a jungle covered with cane and threw it into that jungle. Thereafter, the village headman informed the police. Police went there and brought the dhow with them. The dhow was a beki, a kind of dhow. I heard that police seized that dhow. The fact may be informed to the village headman by
So he's not eyewitness.
He's not eyewitness.
Then how does it matter? Then why are you reading all that?
I am reading, my lord, because two things, my lord. He witnessed none at the place of occurrence, my lord, and he had seen Sarumuni Deka also sustained injuries, my lord. That PW6.
Where? Where does it?
My lord, 7th line, my lord.
Ah,
Uncle Sarumuni Deka was also coming with elder brother, and Sarumuni Deka also sustained injuries. This has been told to him by Sarumuni Deka. Then, my lord, leaving on the following day in the hospital, when I asked my uncle Sarumuni Deka, he replied that while he and my elder brother Komola Deka returning after so and so, my lord, who kept hiding themselves behind a bamboo grove, came out. Orun Deka dealt a blow on the neck of Komola Deka, and when Putuk Deka tried to deal a dhow blow on my uncle Saruram Deka, the blow fell on his hand. Dhow blow, my lord. That is what I'm trying to point out, my lord. Because
So?
in the medical, it comes out fresh, blunt.
so
Sarumuni Deka's medical, my lord, it comes out as fresh and blunt. Then, my lord, cross, my lord. I'm saying about the incident after hearing it from other people. I did not witness the incident. He is not an eyewitness, my lord. PW2 same, my lord. In the cross, my lord, page 13. I did not see the incident. He is also not an eyewitness, my lord. Hearsay, my lord. PW3 same, my lord, page 16 cross, my lord. PW4 also same, my lord, page 18. I do not know much about the incident. I didn't witness the incident, my lord, page 18. PW5 again, my lord, same, my lord. PW6 is Sarumoni Dekha, my lord. Page 21. my lord. I know the accused persons. Informant Konrapo Dekha is my nephew. They are my nephews. Both of them are brothers. Deceased Kamala Dekha was my nephew, the son of my brother Deven Dekha. Accused persons and the deceased were cousins. The incident took place around 4:30 p.m. 4:30 p.m. on that day, my lord. About 2.5 years back at Kodomara Sapuri. Kamala Dekha and I was sowing lentils at Kodomara Sapuri. After completion of the task around 4:30 p.m., we were returning home. When we crossed about half a mile, Orun and Ghotak came out from Horichandra Dekha's house. Kamala was ahead of me. At that moment, Orun hacked Kamala Dekha, who was ahead of me with a dao. When Ghotak Dekha hacked me on my right arm from behind, I turned around and saw Ghotak attempting to hack me for the second time. So I ducked and ran away, and therefrom Kamala Dekha remained there. Running away, I went to my elder brother Deven Dekha's house at Medi Sapuri and informed them about the incident. Seeing me in injured state, someone took me to village Rongamati by crossing the river. There I searched for the Gaubura village headman, but I could not find him. Malavu, kindly see, Malav. Then I went to President Minaram's house. The PW9 says that it was Minaram who came and threw the dao in his compound, Malav. It comes out in the cross, Malav. Then I went to President Minaram's house, but there too I did not get the numbers of the Gaubura and the police station. Again, I went to the Gaubura's house. While I had been sitting there, somebody called 108 ambulance and took me to civil hospital.
So this Sarumoni Dekha and this Saruram Dekha are same.
Same. He is known as Sarumoni Dekha and Saruram Dekha. PW1 says so. In the meantime, police vehicle also reached there and police questioned me in the 108 ambulance. So kindly see, Malad. In the meantime, police vehicle also reached there and police questioned me in the 108 ambulance and took me to the hospital saying that I didn't need to go to police station. I told the people about the incident. Doctor treated me and gave me stitches in the hospital. Man. He's trying to project much of that he was examined on the day of the incident, my lord, and he was given stitches, my lord. It will come out that day also, my lord. It will come out in the IOS cross, my lord. That is 161 was taken on 8th, my lord. That is 5 days after the incident, my lord.
The incident took place when?
On 3rd, my lord. And I've checked the record also, my lord. Flag mark the 161 of Saruram Dekha. It's 8:10, my lord. (8:10) 2015, my lord.
Yes, then what?
I remained in the hospital for a day. When police called me, I went to Mongoldoy court. Well, one more thing, my lord. Took me to civil hospital, my lord. The medical is from civil hospital, my lord. His medical, my lord. I remained in the hospital for a day. When police called me, I went to Mongoldoy court, and there the magistrate recorded my statement under 164 CRPC. I put my thumb impression in the statement. In the night when I was in the hospital, police took Kamala's dead body to the police station. From there and later on, they took it to the hospital and got the post-mortem examination done. Kamala had died on the spot. At the time when Ghotak hacked me and I ran away, Orun directed Ghotak to kill me, but I managed to escape. From there, later on, Kamala was cremated. Later on, Kamala's younger brother Kondorpo lodged the case. My father had given a plot of land to my unmarried sister, Remoda, and since she had entrusted me and Komola to cultivate that land, we plowed the land with tractor and did cultivation there. Cross, my lord. Lord, may I take page 23 directly, my lord? That suggestion, my lord, that he was the perpetrator of the incident, my lord. Fourth line on page 23, my lord. It is not a fact that at the time of the occurrence, I had dispute with Kamal in connection with doing cultivation and with regard to Premoda's plot of land. It is not a fact that since I had dispute with Kamola in connection with Premoda's plot of land, I killed Kamola, and to save myself, I implicated the accused persons and informed the Gaubura. It is not a fact that since I had dispute with Kamola in connection with that plot of land, I hatched a conspiracy, called Kamal to a secluded place and hacked him to death. This suggestion, my lord, has been given to all the PWs, my lord. This is the defense case, my lord. And my lord, PW1, when it reaches the place of occurrence, sees none, my lord. It can be seen that PW6 is telling everybody about the incident, my lord, as per his version, my lord.
Who is the appellant? What's his name?
The appellant is Orun Deka, my lord, and one more. Hema Deka. Hema Deka alias Kotok, my lord.
Arun Deka.
Orun Deka. Oh, Arun Deka, my lord.
And there's
And
one-
Hema Deka alias Kotok
There are two
Deka.
appellants, two appellants.
Who appellant?
Two appellants.
Hema Ghotak Deka and Hema Deka are same. And Arun
Acha. Arun Deka and
Hema
Hema
Deka.
Deka,
Hema
Ghotak, who is also known as Ghotak.
they are brothers.
Their brothers. Then my lord, PW 7 is same, my lord, not eyewitness, my lord. But there is one thing that comes out page 24, 25, my lord. Fourth line, my lord.
Yes.
First, police took Bhutak Deka alias Hema Deka to the village and the place where the incident took place. Police also took us along to the place of occurrence as well as to the adjacent place says to search for the dhow with which Komola Deka was hacked, but the dhow could not be recovered. That is called leading to discovery, my lord.
So there was no Caesar.
Caesar was there, my lord, on the part of PW9. He says that Orun Deka came in his chief, my lord. He says Orun Deka came through the dhow and ran away. He got scared. He threw the dhow in a secluded forest, my lord. And then when police came, he told police the dhow, my lord. In cross, it comes, my lord, that in before police yet said that the dhow was thrown into his house by Minaram, one Minaram, my lord. Minaram is that president who PW6 met after the incident, my lord. That comes out in PW6's cross, my lord. Lordship is no liberty, my lord. Read only one line of PW6, my lord. Then I went to President Minaram's house, but there too I did not get the numbers, my lord. PW9 says that Minaram was the one. In chief, he says Orun Deka, my lord. But before police, and that contradiction is proved, my lord, that was Minaram, that president who had thrown the dhow into his compound, PW9's compound.
Okay. Let us see the pattern. Yes.
The PW9 is page 28, on whose instance the DAO was recovered. Dinesh Soikia, PW9, page 28. I know the two accused persons in the case. I know the informant. The house of the accused is 1 kilometer away from of mine at Nis Rongamati. I knew deceased Komala Dekar. I also know injured Saruram Dekar. The incident took place some 2.5, 3 years ago. Around 1:30 o'clock one day, Arun Dekar came to our house. I was present at home. Arun Dekar came, threw away the dao near the.
Yes.
Arun Dekar came to our house. I was present at home. Arun Dekar came, threw away the dao near the courtyard, asked for water, and left after drinking the same. Later, I saw the dao left by Arun Dekar near our courtyard, and when uproar erupted at the Moza, about 1 hour thereafter, I came to learn that Arun Dekar had murdered Kamala. Then out of fear, I crossed the river, which is at some distance from my house, and after throwing the dao in the cane field in the house of the Gaubura village hetman and taking bath in the river, came back to my house. After 2-3 days, police came to my house. Police questioned me. I went to show police the place of where I had thrown the dao. Accordingly, police recovered the dao. Police seized the dao and obtained my signature, so and so, so and so. Then cross, my lord. It is not true that on being questioned by police, I stated that Minaram Sohoria had thrown the said dao in the night. Blood was sticking to the dao. Well, this contradiction is proved in page 36. Before the IO. Then, my lord, PW10, my lord, is Caesar witness, my lord. To the dao, my lord. Page 31, my lord. I do not know to whom the dao belongs to. Since police asked me to put my signature, I did so. I did not see the dao properly. Page 32, PW11, also Caesar witness, my lord. Yes, same thing, my lord. Page 34 is the IO, my lord, PW12, my lord. Page 34 is the IO, my lord. PW12, my lord.
Yes.
Page 35 may take my lord's, my lord.
Yeah.
Fifth line, my lord. The dao used in the incident could not be found. On 5/10/15, accused Hema Dekar alias Potok Dekar appeared at the police station, whereupon I interrogated him, forwarded him to court after arresting him, and took him into custody on remand. After questioning injured Saruram Dekar, he was produced in court on 8/10/15, and a prayer was made to court for recording his statement under section 164 CRPC. And accordingly, statement under section 164 CRPC was recorded. After questioning injured Saruram Dekar, he was produced in court. After questioning injured Saruram Dekar, he was produced in court, my lord. He was questioned by the police on 8th, my lord. That is 5 days after the incident, my lord, and he was sent to court also, my lord, on 8th, my lord. On 7/10/15, Arun Dekar surrendered in the court. On 10/10/15, on being shown on 10/10/15, on being shown by Dinesh Sohoria, I recovered the dao from a jungle at Bhutiapara, Maina Ghat, Chuba, and seized the same in presence of witnesses. Then take my lord, page 36, man. Of the IO, my lord. The last part of the second level, Saruram Dekar. Hello, kindly see, my lord. Saruram Dekar got treated of his own. He did not go to treatment or requisition of police. Saruram Deka was questioned at the PS at about 10 a.m. on 8/10/2015, subsequent to his release. Page 36, man. Saruram Deka got treated on his own.
No, you see, he got injured. Why should he go to the hospital through the police? Why should I bother? I'm injured. My hand has been chopped by a dao. You're not going to think about going to the police. You're going to go and think about yourself first.
That treatment he took was in civil hospital, and that treatment was on 8th, and that treatment, the medical report shows blunt and fresh. He got treated by his own at civil hospital. He says so in his cross as well, civil hospital. Isolacerated injury in the right arm of Saruram Deka. It was slightly swollen. In his statement of section 161, he mentioned the names of the accused persons. I investigated the case on the basis of his statement. Except Saruram Deka, there is no other eyewitness. I recorded the statement of PW Dinesh Soikia under 161 CRPC. And in his statement, he has stated that the seized dao was thrown by Minaram Savoria. I did not send the seized dao to FSM. The dao part possibly goes more because it's 37 is a doctor man. PW 13 man. It's 37 is a doctor man. PW 13 man. He performed the postmortem and he was a doctor who treated PW 6 man. Page 30 is the last line. Cut marks seen on right and left scapular region. Page 38 is the opinion. In my opinion, the cause of death is due to shock and hemorrhage. As a result of injury sustained, the injuries are antemortem in nature. One of the last part of page 38, on 8/10/2015 at 2:40 p.m. while I was serving as SDM and HO at Mongoldoy Civil Hospital, I examined Saruram Deka, age 56 years, son of so-and-so, village so-and-so, in connection Mongoldoy PS case number 851/15 and found lacerated injury on right arm. In my opinion, the nature of injury, fresh, simple, and rapid blunt. With a dao, my lord, it cannot be, my lord, simple, my lord.
Why not? It can be from the backside of the dao, the blunt part. Doesn't have to be through the sharp
Blunt,
side.
but cannot be fresh, man.
Maybe the wound has again opened up.
Fresh injury entails.
Maybe the wound has opened up. If you get a cut sometimes, it opens up if it's not stitched after a few days. Have you been cut? Have you been ever cut? Have you ever been cut by a knife?
It wasn't cut. That is why I'm trying to point out, my lord. Simple and blunt. His skin was not cut, my lord.
Major. Simple and cut. Simple. Found lacerated injury. Lacerated means what?
Some abrasion on the skin, but
Abrasion.
some laceration on the skin, not cut.
Yeah.
Not cut, my lord. That's what I'm trying to point out, my lord. Page 102 is his medical, my lord.
Yeah. 102.
102 is the injury report, my lord.
Fresh and simple.
Fresh, simple, and blunt, my lord. On 8/10/15, my lord. On that day, I faced judgment before my lord. That Khema, my lord. This 122, my lord. May I read it again, my lord? No, I had given lordship that copy on Monday.
A copy of?
This judgment, my lord, Monday. 2022 SSC online SC 991.
2000?
22.
Yes,
SSC online SC 991.
yes. Para?
Well, para 3 lordship kindly note see one line. Madam. 7th line, not lordship has seen, madam. All of them. Lordship has seen, madam. All of them started assaulting deceased Prakash
Yes.
and threw him on the brick road. Inder PW2, brother of deceased Prakash and his sister Omwati's wife Kripa came forward to save the life of deceased Prakash. However, the accused persons assaulted them as well. In the said assault, Inder PW2 suffered gunshot injury. Then I paid para 17 money.
Yes.
The incident had occurred on 27th April 2002, my lord. However, the statement of Inder was recorded under section 161 CRPC on 21st May 2002, my lord. Same as in our case, my lord. In his cross-examination, he admitted that the police did not interrogate him on 30th April 2002. Not only is there a long delay in recording his statement, but there are serious discrepancies with regard to the medical examination of Inder as well. In the injury report, the time of examination stated to be 10:20 p.m. From the evidence of Ombi PW1 and Inder PW2, it is clear that after the incident occurred, they had gone to the police station Shergar, and they were in the police station Shergar from 10 a.m. to 11 a.m. In his evidence, PW2 has stated that he reached the hospital at 12 o'clock and that his medical checkup was done during daytime. In his examination in chief, Dr. Onup Kumar has stated that there was a possibility that the injuries were inflicted at 8 a.m. The kindly Srimala has stated that there was a possibility that injuries were inflicted at 8 a.m. on 27 April 2002. In his cross, he admits that in the report of medical examination, he has mentioned the injuries as fresh, meaning thereby that such injuries had been inflicted within a period of 2 hours to 6 hours. He further admits that the medical examination was done at 10:20 p.m. on the date of the occurrence, for 27 April in this case, mirror. As such, the injuries could not be inflicted subsequent to 4:30 p.m. In this case, the occurrence as per the prosecution was in the morning at 8 a.m. on 27th May. But the injuries were fresh, which meant that the injury was caused no later or on or before 4:20 p.m. on that day. That's 6-hour gap, my lord, because it was a fresh injury. In our case, in the present case, my lord, this medical was done, my lord, 5 days subsequent, and it came out as fresh, my lord. So that 6-hour to 8-hour gap, my lord, it could have been at least on 7th, my lord, that injury, my lord, at best, my lord. Then, my lord, para 21, my lord. This court in the celebrated case of Vadivelu Thevar versus State of Madras has observed that, hence, in our opinion, it is a sound and well-established rule of law that the court is concerned with the quality and not the quantity of the evidence, and necessary for proving or disproving a fact. Generally speaking, oral testimony in this context may be classified in 3 categories, namely wholly reliable, wholly unreliable, neither wholly reliable nor wholly unreliable. In the first category of proof, the court should have no difficulty in coming to its conclusion either way. It may convict or acquit on the testimony of a single witness if it is found to be above reproach or suspicion of interestedness, incompetence, or subornation. In the second category, the court equally has no difficulty in coming to its conclusion. It is in the third category of cases that the court has to be circumspect and has to look for corroboration in material particulars by reliable testimony, direct or circumstantial. We find the testimony of Inder, PW2, who had suffered the gunshot injury, would fall under the third category. His evidence can be said to be neither wholly reliable nor wholly unreliable. As such, it will be necessary that there is some corroboration to his ocular testimony. That is page para 22, my lord. Then para 29, my lord. From the perusal of the evidence as well as the findings of the trial court itself, it is clear that so and so, my lord, cannot be treated as eyewitness. Then, my lord, though injured PW2 was an injured eyewitness, there are serious discrepancies and inconsistencies with regard to the time of the injury sustained and time at which he was medically examined. With that discrepancy, my lord, the Supreme Court acquitted the accused in the present case, in this case, Khema Mari. Then, my lord, there's another I place for 2016 4 SCC, my lord. That Shahid Khan, my lord. Yes. 2016 4 SCC, page 96, my lord.
Para?
There are 20, my lord. The statements of PW25, Mirza Majid Beg, so and so, PW24, so and so, were recorded after 3 days of the occurrence. No explanation is forthcoming as to why they were not examined for 3 days. It is also not known as to how the police came to know that these witnesses saw the occurrence. The delay in recording the statements casts a serious doubt about there being eyewitnesses to the occurrence. It may suggest that the investigating officer was deliberately marking time with a view to decide about the shape to be given to the case and the eyewitnesses to be introduced. The circumstances in this case lend such significance to this delay. PW so and so, in view of the unexplained silence and delayed statement to the police, do not appear to us to be wholly reliable witnesses. PW 6 in his cross, my lord, says that he was examined on the same day, my lord, but it comes out in the cross of the IO, my lord, that he was only examined after 5 days. And my lord, if PW 6 is falls in the third category of witness, my lord, that's wholly unreliable, neither wholly unreliable nor wholly reliable, my lord. This testimony, ocular testimony, falls short, my lord.
That's all.
There are 2 more judgments.
313, what does he say?
313, they both say, my lord.
He denies everything.
No, my lord, this is this, my lord. Page 48, my lord, is Hema Dekka's.
The other one denies everything. Arun denies everything.
He also says, my lord, page 44 is Arun's 330, my lord. Question number 20.
Except for page 44, he denies.
He denies, my lord. He says in page 44, my lord, he was called to the police station. He voluntarily appeared, my lord. He does not know about the incident. He was in social relation with Kamala Dekka. He is my son's uncle.
Yes, what are the other judgment?
Page 48 is the other one.
The judgment?
This is 2010 3 SCC 721, my lord. Uttar Pradesh was a Guru Chairman.
Para?
Para 35. My lord. She kindly finds para 35 and turns the page, my lord. After the full stop, my lord, fresh injuries also be seen, my lord. Fresh injuries are the injuries which are caused within 6 hours. No doubt there may be variation of 2 hours on either side, As the fresh injuries could be termed injuries within 4 to 8 hours and not more than 8 hours.
Where do you get this fresh injuries should be within
This
6 hours or 8 hours, 4 to 8 hours?
No,
Who has made this?
this is the I found this in Supreme Court, madam.
Supreme Court, has the doctors done it? Other judges the best persons who can say whether an injury is fresh or not, or whether we should we leave it to the expert?
So the expert said fresh, madam. But since in the injury report,
Where the experts said? Experts have not said. Where have the experts said?
well, in our case, the expert said fresh, madam.
That's a different.
But
that's a different thing.
But that
I'm
is-
saying,
Because in
Isn't
that fresh, my lord, he has not mentioned the duration of the injury, my lord.
anything else?
Look, kindly appreciate, my lord. This is
We are
not,
hearing you, Mr. Counsel. It doesn't mean that we have got to say yes to everything that you say. We are hearing you. We are saying maybe.
my lord, my lord.
We are not saying any other thing. You cannot. Don't think that just because we are questioning you,
No, my lord.
that we are not
Never-
trying to
no,
decide
my
a matter. We have already made up our mind. We have not made up our mind.
No, my
So
lord.
please, otherwise you're wasting time also. The other cases also we've got to hear. Please go to the next point. Last judgment. This is the last judgment.
Last, my lord, there's another one on,
You said two, now you have reached three. Please, Mr. Counsel, how many judgments are you going to give us? Please give them all to us now. Don't give us one by one. Yes, now tell us which paragraph,
this was 2020, 12 SCC 605, my lord.
page, para.
The preceding para 44, my lord. This is an internal para of some other judgment, my lord. Just before para 44, my lord.
Yes.
Thus, the position of law in cases where there is a contradiction between medical evidence and ocular evidence can be crystallized to the effect that though the ocular evidence of a witness has great evidentiary value vis-a-vis medical evidence, when medical evidence makes the ocular testimony improbable, that becomes a relevant factor in the process of the evaluation of evidence. However, where the medical evidence goes so far that it completely rules out all possibility of the ocular evidence being true, the ocular evidence may be disbelieved. Then, मतलब para 51, मतलब why in this case the ocular was disbelieved?
Yes.
Para 51, the real contradiction comes in the form of testimony of PW2. PW2 states that Resham Singh fired the shot from behind after climbing in tractor, which has struck at the back of the deceased, whereas PW1 has deposed that all the accused came, stood at front, and all the three had fired the shot from the front. Mind. In this case, the gunshot wound was from the back. Mind. Because of this discrepancy between the ocular and the medical, my lord, the eyewitness, the purported eyewitness was disbelieved. My lord. I'm trying to draw parallel is that my lord Saruram Deka says that he was hacked by a dove. That he's an eyewitness, my lord. He's an injured witness, my lord. But the medical completely completely rules out the possibility, my lord. The ocular evidence is true, my lord, of Saruram Deka. My lord. And then, my lord, the last one, my lord. 2016-16 SCC page 701. This para 18. my lord.
Para 18.
Para 18. my lord.
Yes.
The evidence of witnesses PWs 1 and 2 disclosed that the primary source of the knowledge about the crime was so and so, who had in turn disclosed to PW1. Similarly, the source of information about the crime for PW3 was a disclosure by Gangaram Sahu and Chaitram. Chaitram had also gone along with PWs 1 and 2 to the police station. However, none of these three persons, namely Jeevan Devangan, Gangaram Sahu, and Chaitram, were examined by the prosecution. No reason for the non-examination is placed on record. The non-examination of these persons goes to the root of the matter and raises serious doubts. The incident was first seen by, as per PW1, one Dombaro, my lord. Had the Dombaro been examined, my lord, whether PW6 is saying the truth or not would have come out. my lord. The Dombaro was the one who informed PW6 first in point of time that Komala Decca had been hacked. my lord.
Yes, anything else?
So that's all. That delay in his 161, that delay in the medical, that shows fresh, my lord, which means at least 8 hours, not more than 8 hours, that injury, my lord. Makes him fall in third category of witness, my lord. And there is no corroboration, my lord. If he falls in the third category, that some corroboration is required, my lord. That is not there, my lord. And that Dombaro been examined, my lord. Possibly they made the case clear. my lord. Obliged, my lord.
The Lordship has already seen PW6 is the only eyewitness. And it is no res integra that solitary eyewitness can prove the case. Now I'll place few points where Lordship can see that he is reliable. Now the question lies whether he is reliable or not. Now I'll just place few lines.
And the injury.
First one, I'll just go one by one. First one, PW6 said that he and the deceased, they went together to sow seeds in their field, in the sister-in-law's field or whoever. Now that is corroborated by PW2 and 7 also. They said, yes, these two persons had gone to sow seeds. The first point is that both of them were together initially in the morning hours. And then PW6 said that after crossing, after they had sown the seed and all, when they were coming back, Kamala was ahead of him, and then he was walking little behind him, and these two persons had come from inside the house of Harichara, that other person, and then Kamala was hacked first by Arun Dekha, and thereafter he was assaulted by that Ghatak Dekha. That he had said, and immediately thereafter he said that I ran to PW2's house. Lordship will see, he said, I went to my elder brother Deben Dekka's house. So Deben Dekka's statement, Lordship can see PW2, he corroborated to the effect that yes, he came to our house. PW2, Lordship will just see few lines from the top. On that day, fourth line from the top, these are the corroborations to his statements to bring reliance to these eyewitnesses account. Fifth line from the top, Lordship will see, on that day, Soru Dekha and my son Kamal Dekha went to sow pulses. This corroborates that they were together. Thereafter, in the Chapori says, so Lordship can skip 2 lines from there. At that time, when After this, in the on that day around 4 p.m., Soruram Deka came running, crossing the river with injuries on his hand and shoulders. So this Saruram Deka came running, crossing the river with injuries on his hand and shoulder. So he had also seen the injuries, plus corroborating the statement of PW6 that he went to this person's house. Then his wife asked him what had happened. Then he replied that Bhatuk Deka had dealt a blow on him and Arun Deka had given a blow on Kamala. The accused duo was hiding behind the bamboo grove when Kamala and Soru were returning on the road. Bhatuk Deka dealt a blow on Saru Deka with a dao, and when he tried to deal the second blow, he somehow managed to save his life by fleeing from that place, and he thereafter came towards Medi Chapuri. When we look backward, we saw Arun Deka dealing blows. So this part that he came to his house with injuries, that is corroborated of PW6. So Peter, there is nothing to disbelieve till this line is concerned. Thereafter, he said that I went to Minaram's house, and there I went to Gwambura's house. Those do not go to the root of the case. And 27 recovery, I'm not placing reliance on, because the Caesar witnesses, they have said they have not corroborated, they have not supported the 27 recovery. So as far as his statement in his chief is concerned, these are corroborated by other statements. So he came with injuries on his shoulder. Then the police had also said that he went and treated himself, and the incident took place on 3rd. Doctor, he had shown to his doctor on 8th, and there is a delay of 5 days. Of course, by that time he was treated, he took his treatment. And fresh will not make any difference, because there is a judgment of the Honorable Supreme Court that if there is any difference between ocular and medical, of course, he has also placed one. Unless the ocular evidence is totally made improbable, then it will not be believed. Then medical evidence will take its will be believed. But as far as it is not totally improbable, then the medical evidence will not be taken into account. It is the ocular evidence that will come. And yes, Lordship had already seen medical. Otherwise, he had injuries in his arm, and PW2 had also said that injuries were in his shoulders. So these corroborates. There is nothing to disbelieve PW6, in my humble submission. And the medical evidence also supports both injuries on Soruram and injuries on Kamala. Kamala, there are cut injuries on the neck, trachea is cut, esophagus is cut. So those assault, and even scapular region, there is an injury. So the evidence of PW6 coupled with the evidence of PW2, the IO's evidence where he had said that he treated himself, and the evidence of medical, the doctor. These corroborations are there, and there is nothing to disbelieve PW6. PW1, what he had said is that the discrepancy of PW1 that when he went there, he did not see anyone. It can be a case where Domboru shouted. Domboru is not cited as a witness even in charge sheet. He was nowhere there. I don't know what happened. And when Domboru shouted, he went, there was no one. At that juncture, perhaps this Saruram also left the place of occurrence. He ran, he fled, and then his brother was lying injured. That can be a case, there was no one there. And on seeing, he became unconscious. And then what Saruram told him is a hearsay. This can be a res gesta evidence that can be taken into account. There are some discrepancy, but it doesn't go to the root of the case. So PW6, there is nothing to disbelieve. I'll just place three judgments rather. One on solitary eyewitness, if your lordship wants. Paragraph 10 of Bhimappa versus State of Karnataka. 2006 11 SCC 2323. I'll read out, I've given the judgment itself by emailing. Here, this line. Lordship, as a Ulapara, 2006-11 SCC 323. I've given the judgment itself to the Ulapara. Paragraph 10. Bhimappa versus State of Karnataka.
Solitary witness.
Solitary
What is the
eyewitness.
citation?
2006-11 SCC
See, page,
323.
para,
10.
party's name?
Bhimappa, BHIMAPPA.
Bhimappa.
Versus State of Karnataka.
What does it say?
It's a short paragraph. I'll read out. They can also take out the print.
If it's reliable, that's all.
Lordship, I'll just read out slowly. However, in the instant case, we are left with the credence of a sole eyewitness, and it therefore becomes the duty of the court to critically scrutinize her evidence. So what is required is that Lordship has to critically scrutinize the evidence with a view to assure itself that witness is stating the truth and that her evidence is so convincing and appears to be so natural and truthful that it is not necessary to look for other evidence to record a conviction. So requirement when there is a solitary witness is that Lordship has to scrutinize it closely and should see whether it is truthful. This is what Bhimappa says in paragraph 10. Yes, sir. Nine. Then place it, I've mailed it, they will get it. Bhimappa. Kali disu, Puravi disu. That's me. Doesn't S. Jahan?
Yes,
Paragraph 10, Lordship, the one that I have just read out.
yes.
The next judgment, Lordship.
Yes.
Next to 96.5.
Yeah.
Lordship. To scrutinize, the duty of the court is to critically scrutinize her evidence with a view to assure itself that the witness is stating the truth and that her evidence is so convincing and appears to be so natural and truthful that it is not necessary to look for other evidence to record a conviction. Because such type of evidence is difficult to find. So what prudence requires is that some corroboration are being gone into. The next judgment is on that. If the solitary eyewitness is found to be partly reliable, then some corroboration is required to be looked into. That is 1996 5 SCC, the next judgment. 96 5 SCC 369. This is Ali Mullah versus State of West Bengal.
What does it say?
If the solitary eyewitness is found to be partly reliable, then some corroboration may be looked into. This is what it is said in 96 5 SCC 369.
That is what he has also submitted with regard to the judgment of Supreme Court in 1957.
That is Arivelu.
2020.
Huh?
Imamala 2020.
But it is referred to a judgment of
Arivelu 1957. Yes, partly reliable.
Ariana.
But this that corroboration part I am placing on.
There
this-
also to set corroboration.
That is also set for. This is paragraph 6. I'll just read out a small part. That the entire case resolves around and rests on the testimony of PW3 only it is now settled position of law that conviction can be based on the testimony of single eyewitness provided the court finds from the scrutiny of his evidence that he is a wholly reliable witness. Where, however, the court is of the opinion that a single eyewitness is only partly reliable, prudence requires that corroboration of his testimony in material particulars should be sought before recording conviction. This is what paragraph 6 says. 96 5 SCC 369. One more judge.
What was the judgment you said?
96 5 SCC
1996, 5 SCC,
369.
369, para.
6. Paragraph 6. Lordship can skip the first line. It is now well established. It is now well established that conviction can be based on the testimony of a single eyewitness, provided the court finds from the scrutiny of evidence that he is a wholly reliable witness. Where, however, the court is of the opinion that a single eyewitness is only partly reliable, prudence requires that corroboration of his testimony in material particulars should be sought before recording conviction. It is in the light of these well-settled principles that we shall examine testimony of PW3. And the last judgment I wanted to place, that is a recent judgment of 2022. It is reported in Manupatra, but I couldn't get it in SCC. Perhaps it is there. I've given the mail. I've sent the judgment only. It is Shahaja, 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 alias Shahjahan, Shahjahan, SHAHAJA versus State of Maharashtra. This is on the point that how an ocular evidence has to be looked into. They have culled out few principles and the guidelines that needs to be seen. This is paragraph 27.
So what is the party's names? Shahaja.
Shahaja, alias.
Is there a, there must be live law?
This is, I have taken out from Manupatra. Manu/SC, it is there, I'll take, oh, he's taking it out. Manupatra, it's easier to find out decisions. We
The
get
problem
all,
is that the paragraphs don't match with the SCC.
sometimes it doesn't match.
Usually doesn't match.
It happens with AIR also, All India Reporter. It doesn't match with SCC. I don't know why it happens.
So that you stick to your own, you know.
The editors have their own.
Yes, either you stick to AIR or SCC.
This is paragraph 27.
Says what?
This is how an ocular evidence has to be looked into, how it needs to be appreciated. Appreciation of ocular evidence. Why I'm saying this is a hard task, and then they have formulated few principles, the Honorable Supreme Court. Paragraph 27 may be looked into. Paragraph 27. Paragraph 27 starts with, the appreciation of ocular evidence is a hard task. There is no fixed or straitjacket formula for appreciation of the ocular evidence. The judicially evolved principles for appreciation of ocular evidence in a criminal case can be enumerated as under. 1. While appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence, more particularly keeping in view the deficiencies, drawbacks, infirmities pointed out in the evidence as a whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witness and whether the earlier evaluation of evidence is shaken as to render it unworthy in belief. These are other words. And then 2, if the court before whom the witness give evidence had the opportunity to form the opinion about the general tenor of evidence given by the witness, the appellate court, which had not this benefit, will have to attach due weight to the appreciation of evidence by the trial court. And unless there are reasons weighty and formidable, it would not be proper to reject the evidence on the ground of minor variations or infirmities in the matter of trivial details. Like in our case, like he said, he threw the dove somewhere Somebody else 3 with. Now, these are minor things and now I'm not pressing on. 3, when eyewitness is then 3 Lordship will see when eyewitness is examined at length, it is quite possible for him to make some discrepancies. But court should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible with the credibility of his version that court is justified in jettisoning his evidence. Minor discrepancies on trivial matters not touching the core of the case, hyper-technical approach by taking sentences thrown out of context here or there from the evidence, attaching importance to some technical error committed by the investigating officer, not going to the root of the matter would not ordinarily permit rejection of the evidence as a whole. Number 5, too serious a view to be adopted on mere variations falling in the narration of an incident, either as between the evidence of 2 witnesses or as between 2 statements of the same witness is an unrealistic approach. By and large, a witness cannot be expected to possess a photographic memory. Say 7, ordinarily it happens when witness is overtaken by events. The witness could not have anticipated the occurrence, which so often has an element of surprise. The power of observations differ from person to person. By and large, people cannot accurately recall a conversation and reproduce the very words used by them or heard by them. They can only recall the main purport. In regard to the exact time of an incident or the time of duration of an occurrence, usually people make their estimates by guesswork. So sometimes there are variations in time and all. So there are so many logic. In fact, there are only 3 now. Ordinarily, a witness cannot be expected to recall accurately the sequence of events which takes place in a rapid succession and in a short span of time. Then 12, a witness, though wholly truthful, is liable to be overawed by the court's atmosphere and the piercing cross-examination by the counsel, and out of nervousness mix up facts, get confused regarding sequence of events. Then 13, final, a former statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction.
Para 28. No?
27. So this is a recent judgment where it is said that how it is to be gauged. Now, coming to our case, there are, of course, discrepancies in the sequence. Those do not go to the root. As far as they going there, they coming back, these people hitting him, he going to PW2's house, PW2 had corroborated, those are there.
What about the that cut mark?
Fresh or the cut mark. That another judgment is there. This is Ganga, which it is 2013-15 SCC, where it is said unless the medical evidence makes the evidence of the ocular witness totally improbable. He had shoulders, cut mark on the shoulder, arm, swelling.
Not doing medical.
Those are same.
That's the
Those are same. Doesn't make it improbable by simply writing the word fresh. The judgment 2015 SCC 298. I did not send it. It's there. Ganga Bhavani versus Raja.
What does it say?
That no undue importance to medical evidence to exclude eyewitnesses, except when medical evidence makes the eyewitnesses version totally improbable. This is 2013.
So it will be with the earlier one also. That 2009-13.
Achha.
Unless oral evidence is totally irreconcilable with the
Then in that case, same thing.
same thing.
These are my humble submission.
But the oral evidence, why I'm saying totally irreconcilable, my lord, he says he got stitches, my lord, in his cross, my lord. Medical says, my lord, blunt and fresh, my lord. Kindly, my lord.
So there was no stitches according to
Not medical, my lord. He says he got stitches, well, he got treated in that same civil hospital, my lord.
After 5 days, the report is
Stitches,
there.
how can be healing 5 days, my lord?
Okay, then
I think Hemadeka is also 302. Nahani? Emma Deka is,
That 323, 34.
oh, 322, oh, 34 is there, common intention. So common intention is difficult to gauge, but from this conduct of the parties, PW6 said they were waiting in there to attack them. So that shows the common intention, they were there. This is the only piece of evidence to show the common intention. PW6 said in his evidence, I'll just read that part. PW6, Kamala, at that moment, or no, when we crossed about half a mile, Arun and Ghatak came out from Harichand Deka's house. This shows the common intention.
Okay. Third, Mr.
Yeah, delay part is there.
N. Mahajan, Learned Counsel for the appellant. Also heard Ms. S. Jahan, additional PP, hearing concluded, judgment reserved. And the IA also will have to be disposed of, I think.
Lordship is still on legs. Can you the matter be taken
Okay,
up?
3. I will do item 3. After this, yes, adjourn for the time being. Yes, let us see. Okay.
My lord, here I'm as amicus curiae, and the appellant was sentenced under section 302. And punishment for life was given.
Let us go to the FIR.
Yes, my lord, your lordship will find it at page 4. It was filed, lodged by the father of the deceased.
FIR dated 14/1/17.
14/1/2017,
Father of deceased,
father of the deceased.
PW.
1.
Yes, this is
It was lodged before the Purani Gudam PP, Nagaon, Assam.
PP means what?
Police point probably.
Police point.
Sometimes OP.
OP or PP probably. This is type. I don't know.
Petrol post.
Petrol post.
Petrol post.
Okay, then.
Complaint against Sri Nirmal Kanti Chowkidar, Balijuri Tea Estate for hacking my son Prasanta Keta to death with an axe. Humble submission is that at about 9 a.m. today, while my son Prasanta Karketa and my neighbor Sri Dayal Ruta's son Sri Deep Ruta went to collect firewood of dead trees from Balijuri Tea Estate, Sri Nirmal Kanti, the Chowkidar of the said tea estate, confronted them on the way and snatching away the axe from them, killed my son Prasanta Karketa by dealing axe blow on his head. Getting frightened, my son's companion Sri Deep Ruta ran away from the spot and gave the news to our home, whereupon I came running to the spot and found my son lying dead there. It is learned that although the public went in search of Nirmal, he had fled from his house and reached the house of head clerk of the tea estate, Sri Venudhar Karan at Borbari. Later on, from the house of Venudhar, he went to the head office of the Langsung through Bamuni Sapanola PW Road, taking with him the blood-stained axe, and from there he appeared at the Samaguri police station.
Okay, so he appeared at the
He
scene.
surrendered.
So
on
he
the time.
surrendered. with
Yes.
it. So it's a clear cut case.
Yes.
It appears.
Yes, it's a clear
Clear-cut
case,
case.
but the learned
Only
trial,
with whether 300 exceptions should be.
it is
under-
a, yes, it comes under the exception of.
Okay, let us see why.
Yes. Why not, at first,
So there is a, so the son, his friend had seen everything.
yes,
Clear.
there is a,
Yes, now why do you say that the exceptions should apply?
yes. Your lordship, the eyewitness is PW2. Lordship will find at page 12.
PW2, PW.
Page 12 is the eyewitness.
Ah,
May I just read? I know the accused Nirmal Tanti, who is the chowkidar of Balijuri Tea Garden. I know the complainant David Kerketa and his deceased son Prasant Kerketa. Prasant Kerketa died about 4 months back. On the relevant date of occurrence, myself and Prasanta in the morning time went to Balijuri Tea Garden for collecting firewoods. We were loading firewoods in our bicycle inside the garden. At that time, Nirmal Tanti came and took away the eggs from the bicycle of the Prasanta. Kindly mark this, from the bicycle, the accused took the eggs. Prasanta requested the accused Nirmal Tanti to return his eggs. Then Nirmal Tanti gave an axe blow on the backside of the head of Prasanta. The occurrence had taken place in front of me. Having seen the occurrence, I raised Halla and Nirmal
what do you mean
Tanti.
by Allah?
Allah.
Why don't they use?
They made you and cry.
I screamed or I hollered or something.
This is a local language. They done Allah.
Okay, then
And Nirmal Tanti fled away.
Allah, Nalla, Kacha, Rasta, road.
Yes,
then-
they don't translate all these things. They keep it same way. And Nirmal Tanti fled away from the scene. I skipped the rest part. The last line, after 2 days, police came and brought me to Nagaon court. I gave my statement before the magistrate under section 164 CRPC, wherein exhibit 2 and exhibit 2 are my
These are all
signature.
okay. Why do you say that?
Yes,
it should come?
now kindly see. Page 49 is 164 statement, page 49.
Page 49.
Page 49,
Yes,
09.
yes, we have got it
Yes.
in front of us.
And on oath, he says, the incident took place at 9 a.m. 14/1/2007.
Is PW2?
His PW2. His 164 statement.
Yes,
He is the eyewitness.
yes.
I went to collect firewood. Prasanta Kerketa also went with me to collect firewood. Nirmal Tanti, the chowkidar of Balijuri Tea, snatched away the eggs from my hand.
How does it matter whether it's from the
My lord, I'm
cycle or from his hand?
I'm
How
not
does it matter?
pressing this, but and dealt a card blow on Prasanta's head with that X. When Prasanta asked Nirmal to return the X, Nirmal hacked Prasanta with X. Nirmal dealt the card blow in my presence. Now I come back to the cross part of the eyewitness. My lord, this will show why I am saying this may be a case of exception. Page 13, the cross of
Yes,
the eyewitness. Presently, I am working as in Ludhiana. After about 2 weeks of the occurrence, I went to Ludhiana in search of job. Prasanta Kerketa is my cousin. He was 14 years old. My house is not within the 4 boundaries of the tea garden. There are labor lines, bungalows, etc. inside the garden. We live outside the tea garden. I am the neighbor of the deceased Prasanta Kerketa. I studied up to class 9. Prasanta gave up his studies. Only on the date of occurrence, I, along with Prasanta, went to the garden to collect the
okay,
fire.
1 minute.
Yes.
The cross-examination of the eyewitness.
No, you please come to section 300.
Yes.
Let's come to section 3.
I am pressing for exception 4.
Exception 4.
Exception 4.
If it is committed without premeditation in a sudden fight,
Yes.
where is the fight?
Yes. That's why that's why-
Okay. In the heat of passion,
In the
upon
heat
a
of
sudden quarrel. Okay, let us.
Yes. Uh, Line about fifth. Only on the date of occurrence, I, along with Prasanta, went to garden to collect firewoods. Prior to the date of occurrence, Prasanta never went to garden to collect firewoods. On 14/1/2017, being the date of occurrence, it was a Magh Bihu. It was Saturday. On the date of Bihu, there is holiday for the workers of the tea garden. At the time when I went to the garden to collect firewood, there was none. I cannot remember in which section of the garden we entered to collect firewoods. In our house, maybe at a distance of about 1 kilometer from the garden. I cannot remember the exact distance to which we went inside the garden. The occurrence took
You
place.
come to the bottom, no,
Yes.
after
Then,
collecting firewood.
Then this is we carried X in our bicycles for collecting firewoods. In the garden lines, there is no manager. I skip this. Then after collecting firewoods,
Yes.
we crossed about 100 meters and met the accused. After crossing the Nala with our bicycles, the accused arrived there. Is the Chowkidar. At that time, we were collecting the pieces of firewoods which fell while we were crossing the Nala of the garden. There was no any instrument in the hand of the accused. There was no instrument in the hand of the accused. The accused in straight away removed the X from the bicycle of Prasanta and moved away. Kindly mark this stage cross examination. Then Prasanta approached him and asked him to return the X. When Nirmal took away the X from the bicycle of Prasanta, there was no altercation between us and the accused. So he denies that there was no altercation, but he says he simply took away the X and he moved away.
Correct.
Then the next page, page 14, when Prasanta pursued the accused with articles to return him the X, the accused gave an X blow on the head of Prasanta. So there should be some altercation, and he pursued. Please give back my X. Now, the line, since the occurrence took place in a single moment, he says, Lordship got it? Since the occurrence took place in a single moment, we could not apprehend the accused.
Where? Which
This
line? are
this
you-
paragraph only. The occurrence
Which
took
line? Which line? Which line?
Fifth line.
Okay, since the
Since the occurrence took place in a single moment, we could not apprehend the accused could hit the Prasanta merely for asking him the X. Then I skip 2-3 lines. Immediately after the occurrence, I remained there for 15-20 minutes. I wanted to save Prasanta. I did not make any attempt to take Prasanta to other place. Then the suggestions were given. It is not a fact that prior to the occurrence, on several occasions, we had stolen firewoods from the tea garden. We had been warned by the garden's authority. It is not a fact that on the date of occurrence, we went to the garden to steal firewoods, and the accused, being the Chowkidar on duty, resisted us. We assaulted him. It is not a fact that the accused wanted to retain collected firewoods from us, and as a result of scuffle, we wanted to assault him, and the accused, in order to save him, Prasanta sustained injury. These were the suggestions, and now the conduct of the accused. And the father of the victim, who is PW 1,
page.
page 10, he also confirms during cross-examination that they are not resident of he is not a worker of the tea garden. They entered into the tea garden unauthorizedly. Page 11 is the cross-examination of PW 1.
Page 11.
Page 11, cross-examination of PW1. I am not a garden worker. The father of the victim. I'm not a garden worker. My house is at a distance of less than half kilometer from the garden. My house is outside the garden area. Then I know that in order to collect firewoods from garden, permission of gardens authority is required. My son and Deep Ruta did not take permission from the gardens authority to collect firewoods from the garden on the relevant day of occurrence. When they went to the garden for collecting firewoods, they carried dao, axe, etc. Not only axe, they had other weapons also. Then he knows that the accused is a chowkidar. Then a suggestion was also given to him. The last
Where does he
paragraph,
say that he does not work in the garden? I'm not a gardener.
I'm not a garden worker.
Okay.
Second line. Then he confirms that his son and the other person who's the eyewitness, they went to the garden unauthorizedly without any permission from the garden's authority with dao, axe, etc. And he was given a suggestion, last two paragraph. It is not a fact that the accused did not intentionally kill my son, but during the process of scuffle, my son sustained injury and expired. It is not a fact that the accused being got to steal firewood from the garden. Now, the conduct of the accused. Prior to that, I would like to go to the medical officer's report and his cross-examination. Page 17. There was only one single blow. Page 17 is the doctor.
Yes.
On examination, I found the following in the
One single blow is enough
one
by
blow.
an axe.
And in cross-examination also, he confirms that. Page 18. Rigor mortis was found present in the time of conducting post-mortem examination. I found only one single head injury.
What more do you want?
So there was, he confirms that there was only one single blow. Now, whether it comes under the exception, that I will try to convince your lordship.
When you chop something with an axe, have you chopped wood? Have you ever chopped wood in your life with an axe?
No, my lord.
I've never chopped. I have.
But it
One blow is more than enough.
enough, my lord. But
More
it
than
was,
enough.
it was in the heat of a patient moment.
So
They were
that does not
stealing
say-
firewoods.
Huh?
He just took away the axe. He wanted to prevent them. They came and asked.
we can speculate on that. That's all.
Then
There
I'll
were no
show.
witnesses.
Then I'll show the 313 statement. He says.
Okay, so
He says it. Before that, just page 19.
page 9.
Page 19, he is PW5. He says a line about
Who is PW5?
PW5 is a school teacher. Seventh line. The accused person, being the garden's chowkidar, resisted them as to why they had collected firewoods from the garden.
How does he know this?
He doesn't say how he came
Was
to
he
know.
eyewitness?
We skip this. We skip this. But the assistant manager of the garden, PW6, is very important because just to show the conduct of the accused. Page 22. The accused Nirmal Tati is a permanent laborer in our Balijuri division of our tea estate. The accused is the present is on the dock today. I know David Kerketa, who is the complainant. I'll skip this. He stated before me, from the previous slide, I saw accused Nirmal Tati was coming towards me on 14/1/2017. He stated before me that he had killed one person by giving X block. Thereafter, I, with the permission of the senior manager, took Nirmal Tanti to Samaguri police station and handed over him to the police. At the relevant time, the accused came with the X by which he had committed the crime, and the accused deposited the X to Samaguri police in my presence. So he went to the assistant manager with the X and says, I have killed someone. It was not intentional. Just to this murder was not intentional. Otherwise, he could have fled away with the X.
Not necessarily, not necessarily.
My lord, I will take your lordship to the 131 statement. Which starts from-
131, there's no 131. You mean 313?
So sorry, so my lord, 313 statement, page 28. Page 28, last question. PW1.
No, no, you see, let us see what the IO has said.
Yes,
What did the IO say?
IO. Page 25, he doesn't say it anything very relevant.
Why did he hit that person with an axe?
Because he was not present and
He should have, he has to interrogate. Why
he has
did you
not
do
done
this?
Because he was not he was at Puranigodam petrol post. He was there, and the accused surrendered.
Mr. Counsel, that's not the issue. If someone is made the investigating officer,
Yes.
it is the duty of the investigating officer to find out why that offense has occurred, why
Yes.
the crime has been committed. For that, once the alleged perpetrator, the perpetrator here is clear, he has admitted.
Yes.
Now he has come to the police. Won't a normal person ask, why did you do it? Where is that? No
Nothing.
question.
Because there was no premeditation.
Premeditation or not, Mr. Counsel. Supposing you hear someone killing someone, okay, supposing you hear outside, you'll ask first of all, who did it, to whom, why? You say, you'll want to know, na? It's the natural inquisitiveness.
But
So-
I
so he
could not find anything.
Huh? No, 313 is different. I am saying at the time of investigation, didn't the IO ask the accused why he committed the crime? Isn't it natural? We can't hear you also.
Any statement given to police, your lordship to be in this civil.
Correct. No,
Barred by.
Whatever it
Yes,
is.
my lord. Yes,
whatever it is.
yes.
It is
Nothing
the
has been
duty
asked.
of the IO to say, yes, I interrogated the accused, asked him whether he did it. Since he admitted to the fact that he did it, wasn't his duty to ask him why he did it?
Nothing has been asked. Nothing has been done. Page 28, the 313 statement.
Yes, 313.
The last part is the question. PW1 David Kakata has deposed that in the morning hours of 14/1/2017, his son Prasanta Kakata went to Balijuri tea estate along with Deepruta to collect firewood, and then you killed PW1's son Prasanta by healing cut claws on Prasanta's neck and head from behind. What is your reply in this regard? No, sir. They had carried firewood on bicycle. I debarred them, but they won't budge. When I snatched away the axe,
So it was basically private defense, it appears. Not, let's see.
when I snatched away the axe, one among them came towards to me to assault. When I retreated, I didn't know what happened. I handed over the axe to the estate.
I handed over the axe to the tea estate.
Probably it's typed copy.
Okay, anyway, when I received, I didn't know what.
He
happened.
handed over it to the police.
Okay, but it appears that you see there was no real. I do not know. Could be yes, could be one also. And,
My lord,
It could have been a private defense also.
yes, my lord. That's
So it
what I
could have
was
come under
trying to,
exception
trying
two
to.
also.
My lord, in this regard, I found a judgment of Supreme Court. I've given 2009-17 SCC 433. A small judgment. It's a similar case.
Yes.
But from paragraph 4 onwards, the trial court found the appellant guilty under section 302 IPC and sentenced him for life imprisonment. The aforesaid conviction and sentence was upheld by the High Court in appeal, hence this appeal. We are of the opinion that the case comes under exception 1 to section 300 IPC, which states as under. Exception 1 has been stated. We are satisfied that the accused was deprived of the power of self-control by grave and sudden provocation which led him to commit the offense. If rubbish is thrown into one's house or shop, one would naturally get very upset. It is evident that the accused had no motive or intention to cause the death of the deceased, since the accused was not carrying the knife before and only picked up during the scuffle with the deceased. We find support in our view from the decisions of this court in Kanhaiappu versus State of Kerala, as well as Masumsha Hasanasa Musalman versus State of Maharashtra. The position may have been different if right from the beginning at the appellant accused had been carrying a knife with the intention to attack the deceased, but this is not the case here. The learned counsel for the state relied upon the decision in Puricherella Nagaraju versus State of AP. In the decision itself, it has been mentioned in para 29 that whether there is an intention to cause death is to be gathered from the several circumstances. And one of the circumstances mentioned in the said paragraph is whether the weapon was carried by the accused or was picked up from the spot. It's a determining factor. If it was carried by the accused right from the beginning, that may be circumstance to indicate that there was an intention to cause death. If it was used for attacking the disease on a vital part of the body, however, when the weapon was not initially in the hand of the accused but was picked up from the spot during the altercation, then it cannot be said that it was a case under section 302 IPC. Rather, it is only a case of culpable homicide not amounting to murder, which comes under section 304 IPC and not under 302 IPC. The observation of the court in the above decision that it is for the courts to ensure that the cases of murder punishable under section 302 are not converted into offenses punishable under section 304 part 1, 2 cannot, in our opinion, be understood to mean that the court should somehow try to find out some way of treating the offense to be under section 302 IPC. In our opinion, there is a clear distinction between a case of premeditated attack with intention to cause death and a case where there was no such premeditated intention and death was caused in the heat of the moment or fit of anger during an altercation or quarrel. No doubt, even in the heat of the moment or fit of anger, one should not attack someone, since human beings are different from animals in as much as they have the power of self-control. Nevertheless, I'm reading paragraph 11, madam. Nevertheless, the fact remains that in the heat of the moment, and is a fit of anger, people sometimes do acts which may not have been done after premeditation. Hence, the law provides that while those who commit acts in the heat of the moment or fit of anger should also be punished, their punishment should be lesser than that of premeditated offenses. It is for this reason the exceptions 1 and 4 have been inserted in section 300 of IPC. Then I skip paragraph 14. In our opinion, throwing waste and rubbish inside the house. Here, the offense was very simple. Somebody who throws rubbish in the house and he blew the knife in the chest. In our opinion, throwing waste and rubbish inside the house of or shop of somebody is certainly grave and sudden provocation. Everyone wishes to keep his premises neat and clean and is likely to lose his self-control in such a situation. The incident in question occurred in a sudden fight and a heat of passion by the sudden quarrel without the appellant having taken undue advantage or acted in a cruel or unusual manner.
Where is the quarrel?
Well, that the suggestion was given, but the eyewitnesses has not admitted the fact. But
So in 313, where is this? Where does he say that there is a quarrel?
well, he says they carried firewood on bicycle. I debarred them, but they won't budge. When I snatched away the eggs, one among them came towards me to assault.
There's no quarrel.
There is no quarrel, but he
So
probably
exception 4 requires quarrel. Now I think you have to dwell upon exception 1,
well,
not 4.
well,
Don't go into the issue of quarreling. There's no quarrel.
that's true. But
There's no quarrel. He stopped them. He tried to stop them. They didn't want to be stopped. Then he took away one of the axes. Then they attacked. So that was. Now the question is whether the action of those persons in coming at the Chowkidar with an axe would amount to sudden and grave
that's
provocation.
the question, my lord.
Huh?
Because they entered unauthorizedly without permission,
That's what-
and he is the chowkidar of that garden. He resisted
Okay,
them.
so that is your case. That's
Well,
your case basically.
My lord.
And yes, so in this in this Nanlal was state of Maharashtra 2019
Yes,
5.
madam.
You have relied upon which para?
Nanlal versus Maharashtra. Para 12.
Para 12.
Para 12 onwards, my lord. 2019. 5 SSC. 224.
No, this is not relevant. Then next. Yes, it has to come within that exception that we know.
Yes.
Okay, the thing is that it should not come within. It should come within. It should not come within firstly to fourthly, but should come within exception 1 to 5.
1 to 5.
That's it. That
That's the good. Because first
for conviction under section 304.
and your honor will kindly see another thing, the age of the accused. At the time of occurrence of incident, he was aged about 54 years.
54 years.
54 years. Now
The age of the accused.
age of the accused,
So incident occurred in 2017.
17.
He's been in jail throughout.
Yes. And it will
Okay,
be-
then Muthu versus state of Muthu 2009-17. Which para?
my lord, this says when death is caused under grave and sudden provocation and
Yes.
without premeditation. in
Yes,
the-
yes. Which para?
My lord, I just have a look.
Okay, leaving this. This is not applicable. Next, what about Gurmukh Singh? Which para?
Gurmukh Singh para 21 and 23.
21.
23.
Okay, 23. Then what about 2015 SEC? Dhirendra Kumar alias Dhiru. Okay, that's all. That's all I think.
That's all. This follows this Gurmukh Singh's
Okay,
ratio.
yes, madam. I think, you see, he's the chokidar.
Yes,
Now, these two persons have gone into a tea garden
unauthorizedly.
unauthorizedly. The evidence of the father, PW1,
Confirms it.
confirms that they have gone unauthorizedly into it. And they have gone to take away wood. Now, if someone goes to your garden and takes away wood unauthorized, naturally, you'll get angry. And he's a chokidar, he's supposed to stop them. So it appears that he's doing his job. Unfortunately, someone got killed. Now, the thing is that grave and sudden provocation appears to be there, as per the thing. The only thing is that the retaliatory force, that has to be proportionate. Now, there were two axes. One is with them, one is with him. So one comes charging at him. He appears to have.
They carried Dao as well as X,
Okay, they
and
can.
he was empty-handed.
No, but
He
then
was
he took away the axe.
He
Yes.
took away the X.
He took away the axe from one of them.
Yes,
So they came charging against him with the axe. Where is that? In
No.
whose evidence?
Well, eyewitness,
Eyewitness. Who?
TW2.
But where does it say?
By the page 13. At the time, from below its 7th line, at the time we were collecting pieces of firewood which fell while we were crossing the nala of the garden. At that time, there was no any instrument in
No,
the
no,
hand
no,
of.
no. That they came. He came. Maybe it's in the. No, in the 313, I think. 313.
Yes,
313 he said, man.
he said.
313 is that page?
Page
Page 29.
29.
29.
Top.
29.
Yes,
Came towards, when I snatched away, one of them came towards me to assault.
assault.
So I think TE means handed over
He
the
state.
So it appears, you see, I don't think it's disproportionate. Of course, he doesn't clarify as to how did they come at him, whether barehanded or
No, that has been confirmed by the eyewitness.
which eyewitness.
This,
He was not carrying anything.
he was not
PW2,
carrying anything. Page 13.
Page 13.
fifth
Below,
line from the bottom.
from below its 5th line.
At that
At
time.
that time, there was no any instrument in the hand of the accused.
Ah.
The accused in straight away moved the X from the bicycle of Prasanta and moved away. He didn't do anything. He just took away the X and he moved away. Then Prasanta approached him and asked him to return the X. When Nirmal took away the X from the bicycle of Prasanta, there was no any altercation between us and the accused. Then the next page, page 14, when Prasanta pursued the accused with articles to return him the X, the accused then gave an X blow on the head of.
That is what I'm saying, Mr. Counsel. You're not understanding the question. You see, when you want to take the benefit of the exception,
My lord.
you have to show that there was some proportionality.
I have
Wait.
given the judgment.
You see, it doesn't mean that somebody comes with you with a pen and then you hit him with you kill him with a rifle or something like that.
No, my lord.
Yeah, so please try to understand the question. Out here, he was asking that the axe be returned. Then you hit him with the axe. How can that be? That is beyond. That is not proportionate. That's what I'm trying to say.
The only eyewitness he has, there is no
There are
one
8 and 9.
that there is no evidence from the prosecution side that there was no altercation.
You see, for provocation or uh, for brave and sudden provocation and for retaliating. Now, where is the evidence that they had done something that made you retaliate by hitting him with the axe?
Yes.
Okay.
There is no evidence from the prosecution side also, but in 313,
He does not say
He says.
but then he does not say that they came with him with an axe or with a weapon.
he says only they came to assault.
They came to assault. So the retaliation that has been done by the appellant has to be proportionate.
Proportional.
Yes.
Probably he has not said because they were-
If someone comes at you with a bamboo, you cannot run him over with a tank or blast him with a tank. You know, it has to be
that has to
proportionate.
be, but
Yeah.
whatever in my hand or whatever I could find to save I could use that weapon. That is also
That is
there.
what that's what I'm telling you. It has to be proportionate. The weapon has to be proportionate.
My lord, your lordship has seen from that judgment, it's only for throwing garbage in his
No,
shop.
no, that is a different issue. I'm talking about that. Okay, some problem arose there. And that might be the start of the problem. But when you want to when you're going to retaliate against some person, then the retaliation has to be proportionate to the action
And
taken by the other side.
probably the age, considering the age, because they are very young and he was a 54 years old person. So he could not have that much of physical force to resist them. That perhaps
Yes, madam.
Yes, Your Lordship. Although provocation part was not there, but they
No,
unauthorized.
provocation was there. Only thing was that the retaliation seems to have been disproportionate.
Yes,
The
yes.
that's what.
But Your Lordship, it was in the vital part of the body, Your Lordship. It was in the head, although it was a single blow. Your Lordship, taken into account the entire fact of the matter, since they have entered unauthorizedly into the garden, and he was not this accused was not carrying anything. He just took out the axe from them, Your Lordship, and it was on a case of single blow, but it was on the vital part. It was on skull, as per the doctor's evidence, also, Your Lordship. It is on the vital part of the body. It may be brought in under the exception, my lord.
How?
Can be a case of because they have entered. He being the chowkidar of the garden, his duty is to protect the garden, my lord. They have unauthorizedly entered, but retaliation was not. Your lordship correctly observed. Retaliation was not proportional. Although it was a case of single blow, it resulted in
Because
the
you see, those persons asked him for the axe back,
Yes.
to return the axe.
Yes,
And then they approached him to assault him.
yes.
With what? That is not clear.
that is not clear. Neither from the prosecution
Was it done
nor
with
from
bare
the
hands
defense side.
or was it with the axe or with the dao?
That is not clear.
That is not clear. So that is causing a slight problem. Because we pass a judgment, then you are going to, in some other case, you will apply that.
Rely. I
But
think.
considering the age, because he is now 60 years
But
old.
the deceased was 17 years of age. He also took away the life of a young boy.
17.
Yes, madam, very difficult. That disproportionate aspect. Your story is fine. Everything is fine.
I get it. Sir.
Only problem that disproportionate retaliation. You know, if at least he had said that they came with me with the axe or with the dao, then the retaliation is proportionate.
Exactly. Moreover,
There is no premeditation
that is clear.
that is clear. Now, probably there's no intention also,
Intention.
Yes.
but knowledge is there. Once you hit with an axe,
If the intention part is not there, if the knowledge is there, your lordship, knowledge and intention has to go.
no, if it's intention, that will be
Intention
3041.
3041.
Then knowledge will be
then
3042.
Can be,
But then only problem is again that hurdle of proportionality comes
Yes.
into play.
lordship, I
Anyway.
decided I have nothing more to say. They have a case, they have brought in a case of general, under general
No,
exception.
no, it's
Yes.
the case is very logical.
Yes,
He's a chokidar.
yes,
These persons have gone to steal wood
yes,
from the garden.
yes. And he was not carrying anything.
He was not
He is
carrying any
carrying
weapon.
anything. And then they came, they
And it's a
charged
case
at
of
him.
single blow.
And it was basically a case of private defense.
Yes,
Only problem was that he should have been carrying a lathi or something better.
yes.
Unfortunately, the axe was in his hand by that time. Anyway, right.
Lordship, he said, when I retreated, I did not know what happened. Maybe he lost his mind, something happened.
No, no,
Vigilanti.
he knew very well. Only thing that he got and he couldn't control himself.
Yes.
That's all.
Probably they
Come if your lordship invokes grave and sudden provocation. It will come if your lordship invokes private defense.
If I, yes. No, even under
It's on the vital
you see,
part.
when you
Single
read
blow.
when you read section, the exceptions to 300, then even if you are going to apply exception 4, that disproportionality will come.
Yes.
You cannot read everything in isolation. There is
Proportionality in strictest sense. and
in strictest sense, yes, in the private defense, that is true, no doubt.
97, Section 97R.
Okay, yes, that
One more judgment under rely on.
Yes, yes.
2022, one I have given already.
yeah.
2022 4 SCC 227. 22
2022
4 SCC
for
227.
SCC 22,
7.
yes,
There are 9 almost. 9.
there are 9. To what effect?
Lordship, when the court bring the case under the general exception, stipulations are given.
Okay. The
And when court can't.
what are the parameters
Yes,
that we
yes.
are to look into? Huh?
Yes. State of Uttarakhand versus Sachendra Singh Rawat.
that is also dealt in this Kormuk Singh, which I have given 2009-15 SCC, as well as in 2015 SCC online.
That para 23, no?
Yes,
All those
yes.
motive till
Yes.
till M, A to M, is there.
My lord.
These are the relevant factors that are to be taken into
Yes.
consideration
Yes.
before awarding
Yes.
appropriate sentence to the
Yes.
accused. I think they've given A, B, C, D to M, no?
In 8.
A, B, C, D.
6 1 onwards. 6
Yeah.
for para 6.
Yes, what does it say? How many parameters have they given? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
9, my lord.
How many? 9 only.
Nature of the weapon used, whether a weapon was carried by the accused or was picked up from the spot,
Okay.
then whether the blow is aimed at a vital part of the body, the amount of force employed in causing injury.
Where is that? Where is our
Given
copy?
the
Or do we have to open our phones also?
2022 4 SCC 227. Para 10 to 13. 9 also relevant. Whereas when page 148, whether the incident occurs by chance or whether there was any premeditation, whether there was any prior enmity, whether was a stranger, whether there was any grave and sudden provocation, if so, the cause for such provocation, whether it was in the heat of passion, whether the person inflicting injury has taken undue advantage or has acted in a cruel and unusual manner, whether the accused dealt a single blow or several blows.
Right.
My lord, just one point which my friend has just pointed out, page 14,
Yes,
the eyewitness says, when Prasanta
yes.
pursued the accused,
Where?
Page
page
Acha,
14,
okay,
second
yes.
paragraph.
When
Second-
Prasanta pursued-
when Prasanta pursued the accused with articles to return him the X. So here the word with articles.
Articles means what? Could be the
Means-
firewood also.
Yes,
Ma-
also,
maybe
Lordship,
a
firewood
lathi,
also
maybe
seized,
a-
my lord.
Ah.
Firewood also was seized.
Yeah, so articles appears to be the
Something was
firewood.
there that we could not
Split
ascertain.
fire.
Articles appears to be the firewood.
Maybe,
Maybe, yeah.
maybe, or they were carrying dao also.
Could be anything.
There could be
Yeah.
anything. So that's just the point of.
Okay, yes, might help.
And one more factor, extrajudicial confession before PW6.
Yes,
Extrajudicial confession.
PwC.
TW6, the assistant manager,
What does he say?
he, page 22,
Yeah,
22.
Para 5 onwards.
2, 3, 4, 5, 6. Sixth line. He stated before me
yes.
that he had killed one person by giving X blow.
So,
Thereafter, I, with the permission of my senior manager, took Hemant Dati to Samaguri police station and handed over him to the police.
so
Extrajudicial confession, what my senior friend is.
that is not disputed.
Is not
That
He
is not
said say it
disputed.
into
That is, no one is saying that it was not done. That's an admitted fact. Okay, right. Mr. Edhar, learned amicus curiae, and Ms. B. Nguyen, additional PP. This appeal has made a challenge to the judgment and order dated 21/12/2017, passed by the Court of the Additional Sessions Judge number 1, Navang, in Sessions Case number 22 bracket N bracket close /2017, by which the appellant has been convicted under section 302 IPC and sentenced to undergo
RI
undergo
for life.
rigorous imprisonment for life with a fine of rupees 2,000, in default to undergo further rigorous imprisonment for 4 months. By sentence order dated 22/12/17, is it?
Yes.
Next date. The learned amicus curiae submits that it is not disputed that the appellant had struck the what, back of the head or what? Back of the head or
Back of the head.
back of the head of the deceased with an axe. On
14,170.
14/1/17, which caused the death of the deceased. He, however, submits that the case of the petitioner, the case of the appellant attracts exception 1 to section 300 IPC, and accordingly the conviction of the appellant has to be altered to section 304 part 2 IPC. Next paragraph. Ms. B. Bhuyan, the learned additional PP, on the other hand, submits. Yes, what do you say?
Lordship, the case can be brought in, but your lordship will decide it's on the
No,
vital
no, I'm
part.
going to decide. What is your submission? I
My
want to record it.
submission is that considering the evidence on record, the case may be brought in under the
Yes,
general
submit that
exception.
on considering the evidence adduced in the trial court. Comma. The action of the appellant may attract exception 1 to section 300 IPC. That's all.
1 or 4?
1.
Okay, 1.
Fourth, there you need a quarrel. There's no
Yes.
quarrel.
Yes.
Matter, there is one thing.
Lordship, one more submission. If I want to rely on the 2012 SCC,
Yes, yes.
then the appellant has to bring out a case that his case was under the general exception. It's his burden under 101.
She further submits. Continue. She further submits that
Para 8.
huh?
Para 8 of the judgment.
Yes, bit part.
We have examined the arguments raised by the learned counsel
eight
for the
of which
parties very carefully.
Which judgment?
2010-12 SCC,
2010.
yes, 381.
Just a minute. (2010).
Vijendra Kumar alias Vijay was the state of Delhi.
We don't have
I have
2010.
given those additions, photocopies. Right.
That is there.
Yes.
That is there. There's nothing.
Then 22 also. 2022 just.
She further submits that the principles, so she further submits that the factors to be considered in determining whether culpable homicide not amounting to murder is attractive under the exceptions 1 to 5 of section 300 IPC would have to be and have been held out in various judgments of the apex court, which have been reflected in the case of state of Uttarakhand versus Sachendra Singh Rawat, reported in 2022 4 SCC 227. That's all. Next card. Right. We have heard the learned counsel for the parties. The prosecution case in brief is that an FIR dated
14170.
14/1/70 had been lodged, had been submitted by the father of the deceased, bracket PW1, to the in charge Purani Gudam PP, Naugam, stating that his son, his stating that his deceased son and his friend and his son's friend, namely Shri Deep Ruta, DIPRUTA, went to collect firewood from Bali Juri Tea Estate, BALIJURI Tea Estate. The appellant of the tea estate confronted them, and after snatching away an axe from them, he killed his son by giving a blow to the back of the head of the deceased. The evidence of the friend of the deceased son, who has been arrayed as, who is PW number
PW2.
2. Number 2.
Yes, Deep Ruta.
PW number 2. Is to the effect that they had gone into the tea garden for collecting wood while loading firewood on their bicycles, comma, the appellant came and took away the axe from the cycle of the deceased. The deceased asked the appellant, who was the chowkidar of the tea estate, of the tea garden, to return the axe. However, the appellant gave a blow with the axe on the back of the head of the deceased. In his cross-examination from a PW2 states that they did not submit any application at the tea garden's office seeking permission to collect wood from the garden. He also states that he knew the appellant before the occurrence of the incident. After collecting firewood from the tea garden, they met the appellant, who took away the axe from the cycle of the deceased. The appellant then moved away. When the deceased pursued the appellant and asked him to return the axe, the appellant hit the head of the deceased with the axe. The appellant thereafter went away, fled away. In his cross-examination, PW2 has denied the suggestion that prior to the occurrence of the incident, they had stolen firewood from the garden on several occasions, or that they had been warned by the garden authorities. He has also denied the suggestion that the appellant, who was the chowkidar, had resisted their attempts to steal firewood, and that they had assaulted him. PW1, who is the father of the deceased, in his cross-examination has stated that he was not a garden worker and that his house was outside the tea garden area. He also stated that in order to collect firewood from the tea garden, permission of the garden authority is required. However, his deceased son and PW2 did not take permission from the garden authorities to collect firewood from the garden on the relevant day of the incident. Next paragraph. The evidence of the doctor from a PW4 is to the effect that there was a deep cut injury in the occipital area, OCCI PITAL, occipital area, bracket backside, bracket close, of the head, and that the skull of the occipital bone was fractured. In the opinion of PW4, the cause of death was due to shock and hemorrhage as a result of the major head injury sustained. As can be seen from the evidence recorded, before that, it is the evidence of PW six, who is the
Senior assistant manager.
senior assistant manager of the tea garden, is to the effect that the appellant surrendered himself before the police with the axe. The evidence, next para, the evidence of PW8, who is the
Lordship, their extrajudicial confession part is also there before PW6.
how does it matter? It's not denied. It's not denied. It's not denied. Who is PW8? Is the IO. Who is the IO
PW8.
of the case? Is that he found upon investigation that a prima facie case under section 302 IPC had been made out against the appellant, and accordingly he submitted his charge. The evidence of PW8, however, does not give any indication why the appellant had hit the back of the head of the deceased with an axe. Correct?
Sir.
No. Yes, para. On considering the evidence, on this time, I've got a meeting at 1:30. On considering the evidence adduced by the learned trial court, it is clear. No, there is no denial with the fact that the appellant had caused the death of the deceased by hitting the back of the head of the appellant, a deceased, with an axe, which had been taken from the deceased, from the which had been taken from the cycle of the deceased. The only question that requires to be decided is is as to whether exceptions 1 to 5 to section 300 IPC would be attracted in the facts of the case. That's all.
That-
Can I make it clear? If your lordship is concluded, well, I don't know.
Yes, yes, yes.
But in respect of item 2,
Eh.
I have some personal inconvenience in the second half. Can it be next week Thursday? Ma'am?
Next week, Thursday.
Yes.
Why Thursday?
Any day, my lord. As per your lordship's convenience.
Uh, Okay, right. uh, On the pair made by Mr. S.K. Taluga, Learned Counsel for the appellate, which is not objected to by Ms. S. Jahan. Additional briefing, this is the matter. In the next week.
Obliged.
Earlier one, your lordship reserved the judgment.
Which one? This
Earlier
one?
matter.
This one, better I'll give it, yeah, just say hearing concluded, huh? So, hearing concluded, judgment reserved. Because now, but then,
There's one more DB.
Huh?
One more division bench.
oh, okay, we've got one more division bench today. Oh, okay, at 2 then. At division bench. It's not so easy like those writ petitions, no? You dispose it off within 2-3 pages. This time you've got to write. Give reasons. I mean, even though you know this is the law, you'll have to again write.
Yes.
Again and again. Same thing. In these petitions, you don't have to say that.
No.
You have to say, Apex court is so has held this in terms of this.
Basically, this, my lord, is based on facts. It is a
Based on fact. So we have to
small
correlate.
factual, my lord.
We're going to correlate
Yes,
the facts
yes,
and the law.
yes.
And, here my sister is helping me.
My lord.
Miss Jahan, can you just come for a minute? I just wanted to ask you something. That other lawyer, you just come.
Nimish.
You just come before one. Yes.
This I is filed for suspension of the order till pendency of
For
under,
suspension of the order.
yes. 389 petition
Yes, yes.
till the pendency of, yes, second time.
Huh? Yeah.
Lordship, earlier it was rejected.
Yes.
This is a fresh IA.
So we want to see if there are new facts or not. If there are no new facts, then what is the requirement of any written objection?
Yes.
Is there any new facts? What is the ground for challenging the, for suspension of the sentence? What is the,
Previously,
the-
it was rejected on the ground that the daughter is adduced before the court regarding the killing of the mother by the accused, means her father. On that ground, it was dismissed.
Huh?
There's the dismissal order.
PW6, daughter of the
PW6.
victim girl, victim, my lord.
no, let us see the order. Let us see
Yes,
the
my
order. Where is it?
Elaborately it has been stated.
Page 21.
Page 21. Yes.
It has been.
No,
paragraph number-
let's go to the operative portion.
Lordship, para 5, page 22.
Yes.
On the other hand, Ms. S. Jahan, learned additional public prosecutor, submits that the learned trial court did not pass the conviction sentence on the basis of the statement of PW5 or the dying declaration, but other relevant evidences. The minor daughter of the deceased and the accused, namely Shriya Sarkar, PW6, had categorically stated that her mother was subjected to physical assault by her father. In fact, it was the applicant appellant who burned her mother. In this regard, Ms. Jahan has drawn attention to this court to para 20 of the judgment of the trial court and submitted that at the time of appreciating the evidences on record, the learned Sessions Judge Dalguri had discussed the evidence of the PW6, who saw her father pushing her mother to the bathroom and thereafter he dragged her
Okay,
out.
so basically, the
Yes.
case of the appellant is that the child was tutored.
Yes.
And so now that is your case, basically. Child was tutored.
Yes.
Now, let us see what is this, and the court had said that that issue will be taken up at the time of hearing, correct? Now, let us see what is the ground taken now.
I don't find any new ground, Your Lordship.
Yes, what is the new ground?
Only that tutor person, because she was
The
with,
tutor point has already been decided. You have to come with a new ground. The same ground, same answer. Supposing I say that you have got 20 out of 30 in your examination. So, and you say, no, I got only 5. Then I come again with the same question to you after 2 months. Same question I say, you have got 20 out of 30. Then you say, no, I've got 5 again. Does that make any sense?
my
It's
lord,
already
in the
decided.
previous application, we were on the ground of the time declaration. Here we are placing the tutor part, that the PW6 was with her aunt for a period of 1 month, 1 year, some months.
So
This
how
is-
does it matter? That means basically tutored. That's what you're saying.
Yes,
Same thing. How does it matter? And dying declaration, you know. Dying declaration is even a dying declaration without is what is your case with regard to dying declaration? It has not been certified by the doctor, or is it that there is no signature or thumb impression, or what?
my lord.
It does not inspire the confidence of the court. It's not truthful. What is it? You have not said anything.
Page number 18.
18 years.
Yes. It's at about 9:30 p.m. Somehow caught me while I was preparing food in the oven. I was brought to Nemcare Hospital, Guwahati. Signature of the patient, signature of the technician, doctor's signature. It was taken by the doctor.
Was it exhibited?
It was exhibited and there's nothing against.
And the doctor himself
That
was
is what he's
examined.
saying.
Okay, there's nothing incriminating. in it.
Trial
Okay.
court relied on the evidence of PW6.
The child. So what is wrong? Child witness, in fact, is your own daughter.
Yes,
Why should she have any ill feelings towards you? How old was she?
8 at the time of addition.
That issue will be taken care of at the time of hearing the appeal here. That's what has been said in the last one. When did this event happen? This incident?
The incident happened, I watched it. 2017, 2/4/2017.
And you have been in jail since?
Yes, what's it?
You have been in jail since what?
My lord, 7 months, around 7 months.
Only?
Yes.
Right. Okay, right. Heard Mr.
M.R. Sadial.
M.R. Sadyal, learned counsel for the applicant, who submits that the applicant had been convicted under section 302 IPC by judgment and order dated 28/7/22, passed in sessions case number 61/2017 by the Court of the Learned Sessions Judge Udalguri. In what is the case number? Sessions case
61.
number 61/2007. He submits that the applicant had prayed for suspension of the sentence and bail under section 389 CRPC earlier by IA number I criminal 521/2020. The same was dismissed by order dated 28/9/22. The learned counsel for the applicant submits that the present application is for suspension of the sentence and grant of bail to the applicant on the ground that the statement made by the daughter of the applicant and the deceased was done after she was tutored while being in the house of the
Aunt.
maternal aunt.
Yes.
Next part. Ms. B. Buyan, additional PP, appears for the state and submits that as no new grounds have been furnished by the learned counsel for the applicant, the present application should be dismissed. So, sir, on considering the submissions made by the counsel for the parties and on perusing para 7 of the order dated 28/9/2022, passed in IA Criminal 521/2022, we find that the ground for suspension of the sentence and bail taken in this application had already been decided in the earlier round, wherein this court had held that the question of the child being tutored before she gave her testimony would be duly considered at the time of hearing of the appeal. As no new grounds are forthcoming in the present application, we do not find any ground to suspend the sentence or release the petition on bail. The application is accordingly dismissed. Madam, I gave you the wrong paper. I found it. What? In the appeal, okay. In the appeal. In the appeal, you write. In the main appeal, you write. As records have not been received by the registry as per the office note dated 8/9/2022, the registry to send the reminder for the same. List the matter after 4 weeks. No, supposing it doesn't come after 20 years. Okay. After 4 weeks. Because now also if it had said, then it would have been a problem.